Ladies and gentlemen, dear friends of the Europa Institute at the University of Zurich, good evening and welcome to another event of the Europa Institute here at the University in Zurich. Tonight, our guest is the Honorable Chet S. Rakoff, a senior judge of the United States District Court for the Southern District of New York, that means basically Manhattan, and an adjunct professor at both Columbia University Law School and New York University Law School. Before going to the bench, Judge Rakoff was a very well-known public prosecutor in New York in the area of white-collar crimes. And afterwards, he was also a partner in two very prestigious firms, law firms in New York, where in both firms he headed the criminal defense section. In 1996, he decided to switch side again and to become a federal judge appointed by President Bill Clinton. That means this very year, Judge Rakoff is celebrating 25 years as a federal judge. Congratulations. During these 25 years, he has authored more than 1,800 judicial opinions. He also served as a commissioner for the National Commission on Forensic Science and as a co-chair on the National Academy of Science Committee on Eyewitness Identification. Chet Rakoff is also one of those judges who declared the death penalty unconstitutional, knowing perfectly that the upper court very likely will overturn his decision. Not for this decision, but the Magnitsky list, he has been banned from entering the Russian Federation since 2013. Finally, Judge Rakoff is known to many New Yorkers and beyond as a regular contributor to the New York Review of Books, one of the finest journals in the United States. Judge Rakoff has received a great deal of press coverage. In 2014, he was listed by Fortune magazine as one of the world's 50 greatest leaders. And for those who read the British Financial Times, you saw him some time ago having lunch with the FT, a weekly interview with leading cultural and business figures. Even the Rolling Stones magazine wrote in 2011 that Chet Rakoff is fast becoming a sort of legal hero of our time. Judge Rakoff has been married to his wonderful wife, Anne, for many, many years, and they are having 3 daughters and 2 grandchildren. Chet has been involved in many important decisions being taken by US courts during the past 25 years. Some Swiss might remember that he also played a role in the, at least in Switzerland, famous Bank Wegelin case, which put an end to the oldest bank of our country. When we at the Europa Institute learned about that case, we decided to invite Judge Rakoff over to Zurich to explain to us that case from a US perspective. And wonderfully, he accepted the invitation right away. On the day Judge Rakoff arrived in Zurich, the Swiss boulevard newspaper Blick, who had learned about his coming, opened with a front-page article in red letters. "Arrest Judge Rakoff today at the airport," suggesting he was an enemy of Switzerland. I have to say, I felt a bit uncomfortable when I was waiting at the airport for Chet to arrive on that day, but nobody came to arrest him. And during this and some other times he spent meanwhile in Switzerland, never ever any incident happened, quite to the contrary. Chet became familiar with Switzerland and became a wonderful friend too. To me, Judge Rakoff is one of my very few heroes. He is bright, he has a great sense of humor, and he has courage, a very rare and wonderful combination. Judge Rakoff was also a good friend of Justice Ginsburg and introduced her wonderfully in the Aula Magna when she gave the Zurich lecture, an unforgettable event here at our university some 6 years ago. Recently, Chet has written a new book, Why the Innocent Plead Guilty and the Guilty Go Free, another paradox of the US broken legal system. A remarkable title for a book written by a sitting judge. We have invited Chet to talk to us about his observations. He will do so over the internet live from New York, not because of a potential arrest threat in Switzerland, but due to the well-known corona restrictions. Dear Chet, the floor is yours.
So I thank you so much, Andy, for that kind introduction. And I don't see any Swiss police outside my door, so I think I can go forward with this lecture. Although with all the nice things you said, I'm really very glad that my wife is not tuned into this because she would demand rebuttal time. The I am a tremendous admirer of Switzerland and um, everything Swiss, especially candy and chocolate, but many other things as well. And it's a privilege to participate in this lecture, even by Zoom. But I want to warn everyone at the beginning that most of what I'm going to talk about, which is what my book is also about, relates really to the American legal system. I am flattered that you would have an interest in the American legal system, but it is very different from the Swiss system or from most systems in most countries of the world. And I think that will become obvious in a minute. I am uh, very proud to be a US citizen. I am very privileged to be a US judge. But most of what I'm about to tell you is about some aspects of the US system that are frankly quite shameful and that we've got to fix before we can hold our heads high. Um, and let me start with the most obvious one, which even some of you folks here in Switzerland may know about, which is mass incarceration. There was a time when the US could proudly say we're number one in cars or we're number one in steel. Now, about the only thing we're number one on is locking people up. Um, every year since the year 2000, approximately 2 million people have been locked up in our jails and prisons. That is 25% of all the people who are incarcerated anywhere in the world. They're China, Russia, forget it. We are far, far more incarceratory. And it also has a disturbing racial aspect. 40% of the 2 million people who we lock up every year are young African American males between the age of 18 and 34. Another 20% are Hispanic males of that same age. They are ripped from their families, they are ripped from their community. They wind up often doing very heavy prison time, which makes them, frankly, uh, more antisocial than they even were before. And the whole thing is something of a fiasco, if not a disaster. What accounts for this? This was not always the American way. Uh, when I was growing up in the 1950s and 60s, um, the U.S. had about 300,000 people in their jails and prisons. Um, and sentences were often quite short. There was an emphasis on rehabilitation and so forth. That changed beginning in the late 60s when the US experienced a great increase in crime, dramatic increase in crime, which continued till 1995. And it became, as one would expect, a political issue. And Congress and the state legislatures passed a whole bunch of very harsh laws, which, among other things, required judges to impose mandatory minimum sentences of 10, 20, even as much as 45 years, um, uh, so-called career offender laws, where if you committed 3 crimes, even if they were fairly low-level crimes, you were sentenced to life imprisonment. And to this day, there is about 10% of the people in American jails and prisons are doing life because of those um, laws, not because they committed heinous murders or anything like that. Um, and there was uh, something called the sentencing guidelines, which were mandatory and very harsh for their first 15 years. They are no longer mandatory, but they are still very harsh. And most judges at least give them some deference, so they still have an impact. Uh, so, as a result of those laws, judges, to a remarkable extent, didn't have any choice but to send people away to prison for long periods of time. Um, the uh, uh, the crime rates began to decline in 1996, and in every year except this past year, they have declined uniformly, and crime rates, even given this, there's been a blip in the past year, mostly related to the pandemic, but even within, right now, the crime rates in the United States are still at levels uh, going that we haven't seen since the early 1960s. And yet we still lock up all these people. We are locking up ever more higher percentage of the people accused of crime, and we are locking them up for longer and longer periods. And the the two chief reasons are that it is politically popular and that the laws require it, and the judges can't do much about it, even though most judges, like myself, are appalled by it. Now, there's some other consequences uh, that flow from all this that are even in their way uh, more shameful. And one is that a substantial number of people who are actually innocent of the crimes they're accused of now plead guilty. And this came about in the following way: because the mandatory penalties were so high, usually the best thing a defense lawyer could do was plea bargain. And plea bargaining, where the prosecutor and the defense counsel, without any judicial supervision whatsoever, meet in the prosecutor's office and work out a plea, and usually because of mandatory minimums, it also determines the sentence. That whole process now accounts for 97% of all the criminal cases in the United States. By the way, in the United States, most criminal prosecutions are in the states, very few in the federal system, but uh, this trend I'm describing is equally true of the federal system as it is of the states. 97% plea bargains. And supposing you're innocent and you are charged in an indictment um, with participation in a drug conspiracy where everyone is facing a 40-year mandatory minimum, whether they were at the top of the chain or the bottom of the chain. And you're at the bottom of the chain, so your lawyer goes and meets with the prosecutor, and the prosecutor says, I agree, your guy is the low level guy. we'll let him plead to a 5-year mandatory minimum. Still pretty harsh when you think about it, but a great deal less than 40 years. So you go back to your client and you say the prosecutor is willing to give you a 5-year mandatory minimum. You have to plead guilty in the next 2 weeks because what's in it for him is getting rid of the low level people in the case so he can focus on the high level people. And of course, you can't plead guilty if you're innocent. And the client, who's typically very poor, comes from a background that has made him very cynical about the American criminal justice system, who previously told you he was innocent, now says, oh, well, maybe I am a little bit guilty. Sometimes that'll be true. Sometimes that'll be false. As a defense lawyer, which I was for 15 years, you never really know. But we do know some of the statistics because in the last 2 decades, thanks to DNA testing, a fair number of people who were convicted, who did go to trial and were convicted, have proven that they were actually innocent and that someone else did the crime. And these are called exonerations. The originator of this was something called the Innocence Project in New York, and they have now exonerated about 370 people accused of the most serious crimes, murder and rape, who proved to be totally innocent. Of those, 10% pled guilty to murder or rape that they never committed at all. They were totally innocent. But it gets worse. There's a broader scale that is put together by a number of law schools called the National Registry of Exonerations. And this includes all cases since 1989 in which a court ultimately found that someone who had previously been convicted was in fact innocent. And that list is up to 2,400 people. And that list includes over 15% of people who pled guilty to crimes they never committed. Now, those two percentages can't be easily applied to the entirety of the system because there was a reason why lawyers got involved in those cases. There was always some doubt about the case, the one case or another. But even if instead of the 15% or the 10%, we conservatively put the figure for the whole system at 5%, 5% of people pleading guilty even though they're innocent, that means, since there are 2 million people presently in prison, that 100,000 American citizens are presently in prison because of their guilty pleas to crimes they never actually committed. And all of this is a function of the much too harsh laws that make it impossible for most people to take the risk of going to trial, even if they are innocent. Now, we should talk a bit also about what happens in those trials where people do go to trial, innocent or guilty. And what we have also discovered, thanks largely to the work of the National Academy of Science, which is the United States' leading scientific organization, that a great deal of the evidence that we used to rely on is highly fallible. One example is so-called forensic science, things ranging from fingerprints down to bite mark or shoe mark or hair matching evidence and so forth. Used to be thought this was highly scientific, really good stuff. And many people went to jail because juries convicted them, believing it was good stuff. The National Academy of Science did a 5-year study and came out with their report in 2009. And um, what they concluded was that most of this so-called science had never been scientifically tested, and that it was highly subjective and it was subject to substantial errors. The um, bite marks, for example, where the claim is made that the bite marks on the victim match the teeth of the defendant, has proven to be erroneous in over 30% of the cases where it has been later tested. The, the most extreme example is hair uh, matching using the claim is that everyone's hair is different, um, and that if therefore a hair is left at the scene of the crime from the person who committed the crime, and it can be microscopically examined. If it matches the hair of the defendant, it only matches his hair, no one else's, and so it must have been him who was the guy who committed the crime. Um, this has repeatedly been found to be totally wrong. It was so wrong that the FBI, to its great credit, a couple of years ago, did a study of the 3,000 cases in which FBI's own experts had testified to a hair match of this kind. And the study concluded that the FBI experts' testimony in these 3,000 cases was either flatly wrong or, at a minimum, materially overstated in 95% of those cases. 95%. There's another reason for wrongful convictions of cases that go to trial, and that is eyewitness testimony. And this is particularly disturbing because it's something that's not easily corrected. When an eyewitness, usually just someone who has no motive to lie, takes a stand at a trial and points the finger and says, "Yes, that's the guy who I saw commit that terrible crime," the jury almost always accepts that as powerful evidence. The guy has no motive to lie. Uh, but for reasons that the witness himself or herself doesn't understand, that testimony is often inaccurate. And here again, the National Academy of Science did a groundbreaking study that was issued in 2014. And they concluded that there were all sorts of unconscious problems with both perception and memory that are intrinsic in the human species and can't easily be cured, let alone even consciously realized. And I'll give you two examples. One is the so called racial effect. People of one race are much less good at perceiving the fine facial features of someone of a different race than of someone of their own race. This cuts across all races. So, uh, white people are much less good at perceiving the fine aspects of a face that is black. Black people are equally poor at perceiving the distinctive features of a face that is white. Um, uh, but the uh, juries don't know about that. And even if they do, it would be hard to apply to any given case. And the eyewitness is typically someone who is quite sure that they remember that this was the person who committed the crime. And that leads to my second example, which is the so called merger effect. So, someone and a bystander sees a crime. They may only see the face of the perpetrator for a minute or two. And if you were able to take a photograph of what's in their brain at that point, it would be a sort of fuzzy image. But a few hours later, when the police have come, the police show the eyewitness a photo array. Sometimes they have a live lineup, but usually it's a photo array, 6 or 7 photos, all roughly similar. so as not to be overly suggestive. And the police person, if they're doing their job properly, will say, um, now, there may not be anyone there who committed the crime, but if there is someone who you recognize as the person who committed the crime, let me know. And the person, the eyewitness, will now study those photographs and say, perhaps, gee, number two is the person I think committed the crime. I am not really sure, but my best bet is it's number two. And he will then have notice, in my hypothetical, that number two has a scar over his right eyebrow. He didn't notice that when he first saw him at the time of the crime. By the time he goes to see the prosecutor 3 months later, or maybe even just a month later, let alone when, if there's a trial, he goes to trial, which would be like a year later, those two memories will have merged unconsciously in his head. And he will now be able to say honestly, but wrongly, I'll never forget the guy who committed this crime because he had a scar above his right eyebrow. And of course, then that will correspond to the defendant on trial, who may therefore be falsely convicted. Now, I've talked so far about the problems, the very serious problems we have in the United States with our criminal justice system as applied to everyday crimes. But I have to honestly say, and somewhat reluctantly, that we also have a double standard. We apply our harsh laws vigorously and harshly to poor people, often people of color, but poor people almost always. We do not apply our laws with anything like the same vigor to rich people or to corporations. And this is a different theme, but let me expound on it a bit. When I was a prosecutor, I was in charge of fraud prosecutions in the Southern District of New York. And the philosophy that I had, but also it had been the philosophy of prosecutors for decades, was you don't go after companies, you go after individuals. Companies are abstractions. It is human beings who committed the crime. You try to find the highest level person who actually was responsible for either committing the crime or at least acquiescing intentionally in its commission. And that's how you find out who is really responsible and you punish them. And the result was that back in that period, we're talking the late 90s, early 2000s, the U.S. government successfully prosecuted the CEO of Enron, the CEO of WorldCom. New York State prosecuted the CEO of Tyco. These are all huge corporations that had been engaged in major, major financial frauds. There was also a widespread fraud called the savings and loan fraud, where the government actually prosecuted 800 individuals all the way up to the number one guy in charge of the fraud, a guy named Charles Keating. This all changed beginning around 2006, 2007. And it was mainly a question of a change in the use of resources. When you go after a corporate crime, if you're looking for who was responsible, it'll take you 2 or 3 years or more to really investigate properly. You start at the lowest level with people who clearly committed crimes, and then you work your way up. Sometimes there is no higher level involved. Many times there is, but it's a complicated, difficult task. You have to show that anyone you're going to accuse of a crime acted intentionally, and you have to show that they uh, did so by proof beyond a reasonable doubt. So that's a major undertaking, and these cases always took many years in the old days. But there's a strange aspect of American law that applies to federal law. It doesn't apply in all states, but it applies to federal law, which is the doctrine known as respondeat superior, by which, under a 1906 decision of the Supreme Court of the United States, even the crimes of very low level people, if taken for the benefit of the company, at least in part, automatically get imputed to the company. So if you want to save resources, um, and you already have some low-level person who's committed a crime, you just bring in the company counsel and you say, you're dead in the water because this crime committed by this low-level person is now imputed to the company. What will the company then say in response? The company will say, well, let us investigate. We know you are short of resources, but we will hire an outside law firm and we will spend 6 months doing a really thorough investigation and come back to you. And they will come back in 6 months, but they will always come back saying, well, yeah, there were a few low level people who were bad. We fired those people, but the company as a whole was not guilty, nor was any high level executive guilty. The prosecutor will then say, okay, well, let's make a plea bargain. That's what happens these days. So they will do a plea bargain. Sometimes it's what's called a deferred prosecution. Sometimes it's an actual guilty plea, but just from the company. The company will pay a fine. It often sounds big on paper, $1 billion, $2 billion. It's usually a small fraction of whatever the company made on the misconduct. And the company will put in place new compliance measures, most of which studies have shown have relatively small effect on any person within the company who is intent on committing a crime. And the prosecutor will then hold a big press conference and announce with much fanfare, today we brought Company X to justice. They have entered a plea. They're paying billions of dollars. They're putting in place compliance measures. And they will totally ignore any high level executive who might have been involved. Now, this has many unfortunate consequences. The first is who actually winds up paying those fines? It's the shareholders who had nothing to do with the crime in virtually all these cases, but they're the ones who ultimately have to pay. Second, the compliance measures, as I mentioned, really rarely have much effect, as shown by the fact that there's a high rate of recidivism among many of these companies. And third, the people who actually committed the crime at the highest level get off scot-free. And to me, that's the most disturbing part of this. Criminality is really personable. It wasn't the company in some abstraction, some ghost that committed this crime. It was the decision made by one or more people. And when it's a great big financial crime involving thousands, if not millions of transactions, it's often someone at a high level. And those people get off completely. So by contrast with our highly punitive approach to poor people who commit crimes, our approach to high level people who commit crimes is one of extreme leniency, bordering on complete ignoring their crimes. Now, I want to say one last word about one other aspect of our system before I conclude, and that is, what about just an everyday person who has a legal problem in the United States. And I'm not talking now about a criminal problem. I'm talking about maybe they have a problem paying their mortgage, or maybe they're in going through a difficult divorce. Do they have lawyers? Not anymore. 30 years ago, almost everyone in that situation who wound up in housing court or family court, as it's called, had a lawyer. Now, over two-thirds of the individuals who are parties, either as plaintiffs or defendants, in those courts do not have a lawyer. And in some states, the figure is as high as 90%. And that's because lawyers have become far too expensive in the United States. The lawyers' rates in the United States have gone up 3 times the rate of inflation over the last 30 years. And there's no end in sight. And the result is that everyday people, not poor people, just middle class people, can't afford a lawyer with terrible consequences. The same studies show that those few who do have lawyers do much, much better, as you would expect, than those who don't have lawyers. So let me end by saying that it is very upsetting to me as a judge that the American legal system has developed over the last 50 years these very serious problems. However, they are almost all fixable. We could do away with those harsh laws. We could provide what are called legal technicians, the sort of equivalent of nurse practitioners who would provide cheaper legal services. We could set up, as the National Commission in its report on forensic science recommended, a national body to assess good and bad forensic science and so forth. What it takes is political will. This will was totally absent during the last 4 years, you will not be surprised to hear. Whether it will come into play in the new administration remains to be seen. So let me end at that point, and I'm happy to respond to any questions anyone has.
Thank you so much, Judge Rakoff, for this great presentation and analysis. It's somehow a short overview on what you wrote in your excellent book, Why the Innocent Plead Guilty and the Guilty Go Free, which I can highly recommend. In your speech and also in this book, you talk about this kind of maybe newer laws with binding minimal sentences for specific crimes. We know that phenomena somehow too in Switzerland, maybe to a lesser extent, but somehow too. I think it's often based on a certain distrust towards the courts. The judges are too soft on crime, right? Where is this distrust coming from?
So when a crime is committed and you read it about it or see it on the media or whatever, the everyday person hears about the terrible crime that was committed and knows almost nothing about the person who committed the crime. And therefore, their natural reaction is throw away the key, lock them up. The judge in the old days, and I'm talking now about before 1980 or so, would pay a lot of attention of why did this person engage in this crime? What can we do to make this person a good citizen rather than a crook? Are there programs we can send them to? And so forth. So a typical sentence in, say, 1960 might be, oh, maybe a few months in jail, but 3 years in a drug addiction, anger management, mental health program. But what the public saw was, hey, he's getting 3 months. That's ridiculous for that terrible crime he committed. So that's where the distrust comes from, but it was not a politically potent matter until crime rates rose. Then it became the source of this legislation that I've described. Now, you might ask, why hasn't it then come down since crime rates have come down all the way since these laws were passed? Um, the answer is that most people say, the reason the crime rates went down is because of these laws. So we got to keep them up. Uh, there are a lot of studies that show that the crime rates have declined for totally other reasons, and that these laws and the sentences played a very small role in the decrease in crime. But that's not the way the guy on the street views it. He says, thank God we've locked them all up, and that's why we don't have crime anymore. So that's the dilemma.
Okay, thank you. Please,
Thank you. My first question is in the acknowledgements you say in 2013 there has been some kind of a change, and that was also the time you have been here, first time in Switzerland. Was that a turning point, 2013? I think it was 5 years after the Great Recession, you call. I think I also saw in the International Bar Association review, you had a large interview. Was that like a turning point for you?
So when I went on the bench, I was not nearly as sensitive to these problems as I became by being a judge and having to impose these sentences, and seeing how different cases were handled, and how so much of the power had been uh, uh, removed from the judge and given to the prosecutor and so forth. And it took me a while to absorb that. And the other thing was, there's a sort of tradition in the United States, I don't want to overstate it, of judges staying out of the public view. That's, after all, they have to be independent, not political pawns and so forth. However, in 2013, I went and took a look at the canons of conduct that govern all federal judges. And to my surprise, I saw that there was a canon that said judges should speak out when they see something that is awry in the administration of justice. Well, all of this has to do very directly with the administration of justice. So, with that combination of growing distress and now an invitation from the ethical rules to comment on it, I wrote my first article for the New York Review of Books, and really that's what got me started on this. My aim in writing the book that just came out is to make the general public more aware. The New York Review of Books is a very distinguished publication, but has a limited readership. And Andy has assured me that every single person in Switzerland is going to buy my book. So,
so this would be 8.5 million, right? In your book and also in your presentation, you talked about this kind of de facto pressure to engage in plea bargaining, in a way, with the prosecutor's office. And the question here is a bit, is this, or are there constitutional limits to that, in a way? In the Constitution, the Sixth Amendments, you have the right for a jury trial, right, basically. But if de facto you have to engage in such a bargain, then you renounce on that right. Have courts ever decided on that issue? How far that can go?
yeah, so an excellent question. The back in the 1960s and 70s, there were a number of cases in the Supreme Court where the claim was made that in death penalty cases, the pressure for an innocent person to plead guilty was overwhelming, because if they went to trial and lost, they would face death. And the Supreme Court in 2 5-4 decisions said, no, it's okay. And they said in one of those decisions, we would be more worried if there was evidence that innocent people are actually pleading guilty, but we don't know of any such evidence. That was 1970. Now, thanks to the Innocence Project, we know there are a lot of those people. So it might be someday revisited by the Supreme Court, but at least for the moment, anything goes under those earlier decisions.
Okay. Okay. In your book, you also refer to like the time before, like Enron or Michael Milken, the junk bond queen. And I had the impression that you say these were better decisions than the plea bargaining today. Is that correct?
Yeah, well, they definitely correct because, by the way, all those cases did go to trial, and these people were convicted beyond a reasonable doubt after a full and fair trial. But more to the point, these were the people who actually committed the crimes as opposed to the companies. I had some of the litigation in WorldCom, which was a very large fraud, billions of dollars in fraud. And the prosecution there was against the CEO, a guy named Bernie Ebbers. And the proof was overwhelming that while he did not initially originate the fraud, he became aware of it quite soon as it grew and basically said, let's go, this is bringing us a ton of money, let's continue with it. And so he went to prison after his conviction. To my mind, he was the guy who could have stopped it. He was the guy who chose to go forward to it. He bears huge responsibility, and he deserved what he got.
There are people who say that with the decision Marbury versus Madison, the Supreme Court, or actually all federal courts, put themselves a bit above the two other branches because they can control what the others do, but the others have no influence on how the courts decide. Now, would you agree that this system of checks and balances might work usually, but doesn't work properly when all three branches are in the hand of the same political party?
Well, that could be a problem, but I would go further. All that Marbury versus Madison says is that the ultimate determiner of what the law means are the courts, which seems to me to be, perhaps I'm biased, but it seems to me self-evident. But there are huge parts of our government that operate without any scrutiny from the courts. The criminal justice system, as I've just tried to explain, is in practice 97% plea bargains that are arrived at in secret conversations in the prosecutor's office without the slightest knowledge by any judge, let alone involvement by any judge. No record is made of the negotiations. It's totally, all the judge knows is when it's a done deal. Another different kind of example is administrative agencies. The Constitution of the United States makes no mention of administrative agencies because they didn't exist back then. But they are now a very important part of American government. They are technically an arm of the executive. So you have in a typical administrative agency, like the Environmental Protection Agency, to take an example, it has rule-making functions, that's the legislative function. It has investigative functions, that's an executive function. It has adjudicative functions, and they have what are called administrative law judges who decide. So it is like a little mini government, but under the Constitution, it's all part of the executive. And that means that the president can change it overnight. So when Donald Trump became president, one of his early moves was to put in place as the head of the Environmental Protection Agency a guy who said, I'm opposed to virtually everything the EPA has done for the last 30 years. Um, so, so there are very large segments of the American government that are not even subject to judicial scrutiny, let alone the kind of power that you were referring to.
Okay.
You variously mention in the book that, like the Sixth Amendment, that, as I understand, a defendant has a right to a jury trial, open court hearing, which for Swiss standards is not so positive. And plea bargaining, I don't know, it's probably not in the Constitution. So what's your opinion on that? It's like...
So plea bargaining is not in the Constitution. It has been approved by the Supreme Court. What happens is, after the plea bargain is arrived at, the parties come before a judge, and the judge advises the defendant of all the constitutional rights that the defendant is giving up. This typically, a typical plea bargain, what they call allocution, approval by the judge, takes about a half hour, of which 20 minutes is just advising the defendant, you have the following right under the Constitution. Are you willing to give that up? You have a right to a jury. Yes. Are you willing to give that up? Yes. If you went to trial, the government would have to prove your guilt beyond a reasonable doubt. Are you willing to give that up? Yes. If you went to trial, the jury would be instructed that you are presumed innocent until and unless the government proves its case. Are you willing to give that up? Yes. If you went to trial, you would have a right to confront all the witnesses against you. Are you prepared to give that up? Yes. This goes on for 20 minutes. All the marvelous, and they are marvelous, protections that the Constitution gives to the defendant are all waived. And the defendant, because he's already decided he wants that 5-year bargain and not that 40-year exposure, says yes, 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 as you recite for him the endless litany of rights that our Constitution provides that he's giving up. And the Supreme Court has repeatedly said that he has the right to give up those rights.
There are questions coming in from the audience, and I might take one that is just following what you said. It says, the change of focus of the US Department of Justice away from investigations to quick plea bargain deals has had another side effect. It has turned the US Department of Justice into a profit center for the US government. It takes in billions each year. Given this goose that lays golden eggs, is there any chance that the US Department of Justice will give up this practice and revert back to becoming a department worthy of the name Justice Department? Question mark.
So a very straightforward question, of course. Towards the very end of the Obama administration, the then Deputy Attorney General Sally Yates, under political pressure and in response to political pressure from the fact that people were very upset that no high-level executives had been prosecuted after the Great Recession, came out with a memo, said, we're going back to prosecuting individuals. That's called the Yates Memo. Unfortunately, that came out just before the election. Right after the election, the Department of Justice disclaimed that memo, and they have not followed it since. But I think what that shows is that public pressure can bring about a change in this policy, and was right on the verge of doing so before the election of Mr. Trump. And so the big question, which I don't have the answer to, is what will the Biden administration do? The new Attorney General, as you know, is a very distinguished judge, Merrick Garland. as Attorney General, he won't have half the fun he had being a judge, but that's his choice. The but it's totally within his power to go back to the old system if he wanted to.
But on the question, I think it's your opinion that it's a wrong system that the shareholders pay. So I don't really think you would oppose that statement.
No, I see the shareholders in all but a very few cases are the victims, or at least totally innocent, had nothing to do with the fraud. Sometimes they reap the benefits because the company made a lot more money, but that's a classic civil issue. So if the company should have to return money that it wrongfully obtained to the people it wrongfully took it to, in the American system, that's handled through civil litigation, which still exists. But why the fines, which was pointed out just a minute ago, go into the hands of the pockets of the government, don't go to the victims, should be paid by people who had nothing to do with the crime, strikes me as wrong.
Your book also says defendants should ask for a day in court. And then you mention that not every defendant will take the risk of the heat of interrogation or cross-examination. You have been an attorney as well for 15 years, so how would you advise to act, especially as a Swiss? Swiss are not used to the direct confrontation in court. Would you have any advice how to take that risk or how to behave?
Well, yeah, I need to narrow the context a little bit. My main proposal in the area you're talking about would be to have judges involved at a much earlier stage. So after an indictment came down, a judge different from the judge who would ultimately be hearing the case if it went to trial, a separate judge would meet with the prosecutor and then meet with defense counsel and maybe with the defendant as well. And these would be recorded sessions, but they would be under seal. They could not be used in evidence. But the judge, by getting involved at that early stage, could see whether there's being fairness in the way this is all being followed, or whether there, for example, leads that haven't been followed up on, or alibis that need to be explored. And he could suggest to the parties individually that they do that. And I think in that kind of situation, most defendants would waive their Fifth Amendment privilege against self-incrimination and talk to the judge because it can't be used against them in a further proceeding. And then after maybe several of these sessions, the judge would suggest maybe that the case should be dropped, or maybe that the case should be plea bargained at a much lower level than most cases are plea bargained now, or maybe that the case should go to trial. And those would be non-binding. The prosecutor and the defense counsel would not be required to accept the recommendation, but I think coming from a judge, in most cases, they would accept it. So that's what I have in mind as a way to make the system much fairer at the plea bargain level.
There's another question from the audience. Colleague Lawrence Ernie is asking, can you explain the system of the public defense? Does a defendant have the right to freely choose his lawyer, and is every lawyer obliged to accept mandates as a public defense counsel?
So everyone has a right to the lawyer of his choice if he can afford him. But in the criminal justice system, who gets caught? It's the people who failed at their crimes, so to speak, looking at it a little cynically. And more often than not, they cannot afford a lawyer. So then under a famous decision of the Supreme Court called Gideon, they are given a lawyer at uh, uh, state expense. Those lawyers are often very good. Many young lawyers want to be a public defender because it's a way to really get into the action at an early age. And so, but if you don't like the lawyer you got from an appointed lawyer because you were indigent and you couldn't afford a lawyer of your choice, you can usually ask for a second lawyer. You can't keep playing this game. You can't ask for a third or fourth or fifth, but you can usually ask for a second lawyer.
Maybe I follow with another question. Do you think the role of a judge in a common law system, as you have it in the United States, you know, in finding the truth, in creating justice, is too passive compared, let's say, to a civil law judge over here in Europe?
Yes.
one more sentence to that.
Yes.
Could a judge do more? Could a judge do more?
Not easily. That question, of course, goes to one of the major differences between the civil law system that is common throughout most of Europe and the common law system that we inherited from England. The common law system, the theory of the common law system is that the judge should be passive. He should be, as Chief Justice Roberts famously said, the umpire calling balls and strikes. And each side will have their champion who will present their points of view, and the judge will then decide. The reality of that is that it often doesn't work at getting at the truth for any of a wide variety of reasons. First of all, most obviously, because most of these matters in the criminal justice system never get to the judge. Second, because often there is a disparity between the lawyers. Third, because even the best lawyers don't always have the time and the resources to pursue some of the questions that a judge might like to pursue. So I think there's a lot to be said for the European system of having a more active judiciary, but it's certainly not our tradition. I don't think it's going to change easily.
I think that Andy showed your new book, and I also have what has been published in 2013, Judicious Activism. So I understand this is what you now say, that judges could be more active, the judiciary. And I also have the impression somehow the prosecutors and the regulatory agencies, they are somehow bypassing the judges. Is that a correct understanding?
Yeah, it's different. The prosecutors bypass it by they now have the power because of mandatory minimums to really figure out, determine everything in the back room. They're not only going to determine what the plea bargain is, but the plea bargain, by the nature of the charges, will determine the sentence. And typically, they also have much greater information than defense counsel. So they start off with a big advantage. So the judge plays a minor role. It once played a major role. It's a big change from 50 years ago. In regulatory, it's a little more complicated. The regulatory agencies are little governments into themselves, but you can appeal. Everything they do is on the record, unlike what a prosecutor does. And you can take an appeal, but the standard of appeal is highly deferential. This may change with the current Supreme Court. And even though I am, you will be shocked to hear, a liberal, I think that the quite conservative Supreme Court may be on the right track in cutting back the amount of deference that courts give to administrative agencies. And I think that may well happen in the next few years.
I know you are a firm believer in the US jury system, but there's a question coming in from Mr. Andre Brandley. He's asking, what are the inadequacies of the US jury system, which is not common to the Swiss court system? Are there any weaknesses in the system that you would acknowledge?
Well, I should start by why I think the jury system is terrific. Jury system means that everyday folks get to make a critical determination. And the result is, in my experience, and I've had over 300 jury trials, and I always talk to the jurors afterwards, they take it very seriously. And they have to be unanimous in their decision. It's not a vote. If they're not all in agreement to begin with, they have to reason among themselves until they reach an agreement, and that's a great thing in itself. So I am a big fan of the jury system, as are most judges in the United States. The weakness, I think I alluded to one of the weaknesses, which is they're not very good at dealing with expert testimony, such as the forensic testimony that I mentioned before. I'm not sure judges are that much better. Judges, very few judges are serious scientists. Nevertheless, that is a weakness. Another weakness is in civil cases, juries can often be too quick to give away a lot of money because it isn't their money, so why not give it away? But a judge in the US system does have the power to cut that back.
Okay.
Another point Swiss are interested in is like the willful blindness concept you have in the US and which we don't know have as such. We have like intent and how would you define willful blindness? I think it's a concept we have first met in the late 90s with dormant accounts, and then of course with the mortgage problems in 2008 and following years, and also in the US tax conflicts we had. It was also always an issue under Swiss bankers and lawyers. What is really willful blindness?
So, willful blindness is a circumstantial way of finding out what is in someone's head. The criminal law that we get from England, but I suspect is similar in most European countries, is you can't be convicted of a crime if you didn't intend to do something wrong. So there's always the problem of how do you find out whether the guy intentionally did something wrong as opposed to acting by accident or negligently or whatever. Willful blindness says that if you wish, you can infer that he knew something was going wrong because he was confronted with evidence that would have led most people to say, what the hell is going on here? And he or she just turned away. So I'll give you an example from a case I prosecuted when I was a prosecutor, which was a case against two high-level accountants in a major accounting firm. And the company that they were auditing would come in usually a day or so before the books were being closed for the quarterly period when they had to report to the shareholders and to the SEC with a brand new contract that would turn a loss for that quarter into a profit. And then lo and behold, over the next few weeks, that contract would be undone and the company would have one excuse after another why that contract did not go through. But under the accounting rules that then existed, they were able to book a certain amount of the future profit of the contract, even at the moment it was signed. Now, what they were actually doing was bribing people in these companies to make these, to sign these false contracts, assuring them that in return for the bribes, the contracts would be undone, a few weeks later. The accountants didn't know that. But after 8 quarters, and that's what it was, where each and every time a loss was turned into a profit by a last minute contract that was then undone a few weeks later, the jury could conclude, as they did, they knew what was going on. They just chose not to inquire. They just chose to wink at it. So that's willful blindness.
Maybe I can add one little thing.
Of course.
I had difficulties to understand as it has criminal consequences, and I thought it's like the 3 monkeys. I'd want to see no evil, hear no evil, and also say nothing. Is it like a bit like this? I have like the 3 monkeys here. Yeah.
It's the analogy it's sometimes given is to an ostrich putting the ostrich's head in the sand to avoid the huge storm that is raging outside.
Okay.
I'm not sure whether you can answer the next question I have here. This is, it says, since you are a judge in the U.S. Federal District of Southern District of New York, how did Preet Bharara do as a district attorney in court?
So he was excellent. He didn't try many cases himself. His assistants were the actual trial lawyers. His big emphasis was on a different kind of crime, insider trading, and he convicted something like 81 out of 82 people he charged with insider trading, which is a pretty darn good record. So I'm a big fan of Preet Bharara. Yeah, he's now teaching law at NYU Law School, but I think he secretly harbors a desire to get back into the public view. That's just my opinion.
Yeah. And what's your opinion on Eric Holder and his statement, which I found in your book on national economy, I think?
So Eric Holder is a lovely person, but the Obama administration kept making excuses for not going after high-level individuals, and the excuses they gave were, in my view, ridiculous. So Eric Holder, when he was Attorney General, said, we can't do this because our economy is already hurting and it will hurt the economy more. Now, that might be an argument for not going after a company, although I still think it's even weak there. But it has no relevance to going after individuals. The economy in the United States is not going to be materially affected by your going after a CEO. So I thought that was a unfortunate statement. Mr. Holder, who's a lovely fella, afterwards said he had been misunderstood.
There is another question from Mr. Arthur Kung. He says, how much influence can be expected from the Enron case on current Boeing case evaluation and judgment, considering internal knowledge at higher executive levels than during Enron and nowadays with Boeing?
Yeah, It's a good question, but there is one area where judges are forbidden to comment, and that is on any pending case, not just before them, but before any judge in the world. So I can't answer that question, but I understand why it's a good question, but I can't understand. I can't answer it.
Okay, maybe Pete, you have a last question? Time is running.
If it's the last one, I would say, when will be your next visit to Switzerland?
So I would be delighted. Please invite me, and not just by Zoom, please. But anyway, no, I'm in love with Switzerland and would be thrilled anytime to come visit.
So then first we have to go through that vaccine program all together, and then we meet happily again. Thank you so much, Chad, for this wonderful first lecture, and now also this discussion and conversation. It was a thrill to have you here. I'm sure we learned a lot about reality in the US legal system, and we are very much looking forward to have you back and to have you on another occasion here. Thank you so much, and all the very best to New York.
And thank you. It's been a great pleasure. And by the way, I hope you guys will come visit. You know, New York is a cold-hearted place, but there are those who love it, including me. So please come to New York when you can.
We do that. Thank you so much. Okay, bye-bye. Thanks. So,
Bye-bye.
ladies and gentlemen, this was the evening with Chad Rakoff. We will have a next internet session next week with the State Secretary from Mr. Seehofer in the German government. He's going to talk about immigration policy of the European Union, another, I think, interesting topic, and I hope to see you back then. Thank you very much and have a nice evening. Goodbye.